That was very nice. Thank you. Thank you, Beth. And this is a wonderful facility. It's just a beautiful gallery. It's a wonderful space to be in, and sort of reminds us of the value of the arts and creating spaces that allow us to be perhaps the most humane of endeavors and be the most humane person we can be. So I will talk very briefly. There's a joke that I often tell about the assumption of risk being sitting in a room with a lawyer, a microphone, and no time limit. So I will limit myself. The clinic, the Community Law and Business Clinic, is located at 8 West 3rd Street. There are some short little view books at the door. We provide a full range of service for small businesses in our community who are trying to create economic opportunity here in Winston-Salem, Forsyth County. And we do that through our law students. Our law students provide tremendous amounts of resources and time every year to businesses and nonprofit corporations in our region. We have 19 law students working in our clinic this semester. If you were to look at a value of the investment that Wake Forest University is making in our community through their professional services and time, it's well over $1 million a year. So we are contributing in very targeted economic development efforts in ways, about $1 million, over $1 million a year in professional services to help build and grow businesses. So what we do, if you are beginning any sort of enterprise that is connected with your work as an artist, we can assist you, connect you with a law student who will help you think through the legal issues that come up, advise you on how to proceed, and help you develop a plan to move from your idea to actualizing that idea into an enterprise that's viable and growing, okay? So today, some of our brightest, most entertaining students will be here talking about some broad topics that connect to the art field, art and law field, and then give you an idea of what the environment looks like. As you have questions after this, you can give us a call at 631-1953 or visit at the website. There's a website address here at the back that will give you a place to submit some information, and then we can work with you during the next academic year. So thank you for being here. Thank you to Winston-Salem State. Belinda, thank you for hosting us. This is a wonderful opportunity for us, and I'll turn it over to our students.
Today we're going to be talking briefly of a number of topics you can see on this outline here: the trademarks, first, and copyrights. And then we're going to work on contract clauses, some of the issues that you should be aware of when you're entering into agreements with maybe consigning your artwork or other things like that. And then tax issues as you're starting to create income and file taxes and pay tuition and all those kind of things.
All right, so like Michael said, I'm Leslie Evans, and I'll be talking to you today about intellectual property. There's 4 different kinds of intellectual property. They all protect the author and give various rights to the author depending on the subject matter that's involved. But the 2 I'll talk to you guys about today are trademarks and copyrights. All right. So the purpose of a trademark is to prevent consumer confusion by helping customers differentiate and distinguish between sources and brands of goods or services. They serve as source identifiers, and the subject matter that it includes could be words, designs, logos, slogans, sounds, product packaging, product configuration, and even colors sometimes. In order to have a valid trademark, there are 2 requirements that the mark must meet. It has to be both distinctive and used in commerce. For a mark to be distinctive, that means it has the ability to act as a source identifier. And there's a spectrum of distinctiveness which ranges from generic to fanciful or arbitrary marks. The mark will likely not be distinctive if it's generic or simply descriptive of what you're trying to offer. It's more likely to be distinctive if it's a fanciful or arbitrary word mark, such as Xerox could be a fanciful mark where the word didn't have any meaning on its own until it was attached to the good. An arbitrary mark could be Apple, for example, which most people associate with a fruit and not a computer. So even though it's a descriptive kind of word, it doesn't actually describe what their brand is. Used in commerce means that you use the mark in the sale or transfer of goods, and you also have to include it on the label or tag or packaging of what you're offering. So once the mark has met both the distinctive and use in commerce requirements, then your rights are secured. Of course, you also have to be the first person to use your mark. And this can be done using either actual or constructive use in commerce. You can have actual use by simply using it in commerce, or you could have constructive use by filing an intent to use app with the US Patent and Trademark Office. It is not required to file an application with the Patent and Trademark Office, although it is recommended. It gives you extra protection and benefits, including the exclusive right to use your mark nationwide, and it also gives public notice to the nation that you are the owner of that mark and that they can't use it. And trademark rights are indefinite so long as you continue to use the mark in commerce. Copyrights were actually thought out by the US founders of the United States, and they included a clause in the Constitution that actually granted Congress the right to create laws regulating copyrights. In Article 1, it's called the Commerce Clause. They grant Congress the right to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Under this language, the goal of a copyright is to offer protection of the expression of an idea through an original work of authorship. A work of authorship is simply a work that someone has created. There are multiple categories that this could include, such as literary works, musical works, dramatic works, pictorial, graphic, and sculptural works, audiovisual works, and sound recordings. Copyright and work of authorship is secured automatically once it meets two requirements. It must be both original and fixed. The originality requirement is basically self-explanatory, and generally any work that's been created by an author is original. Fixation, it must be fixed in a tangible medium of expression. What this means is it actually includes a very broad range of subject matter once it's fixed in a tangible medium. And that can include things I've listed on your handout, such as books, manuscripts, paintings, drawings, sound files, etc. And once you have these two requirements, you actually do not need to place a copyright symbol on your work. You can if you want, but it's not required to have a copyright in the work. Once these two requirements are met, you will have copyright in your work that you created. And once you've secured the right to a copyright, you're granted a series of exclusive rights in your work. These include the rights to reproduce your work, create derivative works based upon your work, to distribute copies of your work to the public by sale, rental, lending, or another transfer of ownership. And you also have the right to perform and display your work publicly. Generally, the author who created the work owns the rights to it, but there are two exceptions where this doesn't count. And these are called when it's a work made for hire. The two situations in a work made for hire exist when the work's prepared by an employee within the scope of his or her employment. For example, if you are a graphic designer for a company and you create a piece of graphic art for that company, the company owns the rights to that work even though you created it and you were the author of it. The other example is if you're an independent contractor or freelancer. And this second category just means that the work was specially ordered or commissioned to be done by you, and the author signed a contract beforehand that the work is to be considered a work made for hire. It also has to meet one of the narrow range of categories, including a contribution to an audiovisual work or a contribution to a collective work such as a book or a magazine. A real-life example of this could be if you were contracted to create illustrations for a children's story, for example. Even though you were the author, that would be a work made for hire. This does not include being paid for work they've already created that already exists. So if you create a work and somebody else pays you for it afterwards, that is not a work made for hire, and if you're the author, you still own the rights to that.
So I'm going to be talking to you guys about contracts and contract negotiation. There we go. Can you guys hear me? Okay, great. So when you're entering into a contract, you have to think about your bargaining power. So what that means is you have to think about what you have to offer in relation to what the other side wants. And that's going to determine your bargaining power. You know, when two people meet to discuss and negotiate a contract, there's always going to be one person who's in a little bit of a stronger position and in those negotiations. And so the other side is going to have to make some more concessions. And so before you enter into a contract, you have to think about what concessions am I willing to make? so that you know where you stand in those negotiations. Now for the sale of art, if you guys are thinking about selling any of your artwork, a lot of contracts are going to have the same terms. It'll have the description of the work, the title, price term, and how that's determined, how the price is determined can vary on a few things that I'll talk about in a minute. There will also be a title transfer clause, just language in the contract saying that ownership is changing hands from your hands to the buyer. And there should always be a copyright retention clause. Anytime you sell anything that is your own work, you should make sure you have a copyright retention clause, which states that even though this person is buying the work, you are retaining the copyright in that work. It is still your work. So that way you can retain all of those rights that Leslie just talked about, like the right of reproduction, the derivative rights. You want to make sure that you're not giving those up in a contract. And then there's some other clauses in a contract that you may want that you're not necessarily always going to get them. So a right of retransfer. So if you have a work of art that you sell to someone and they are going to sell it to someone else, you can have an assignment clause which makes any new buyer bound by the original agreement that you signed with the first buyer. Or you may have a clause that gives you maybe 30 days notice before the new owner gets to sell your work. And then also you might wonder if you still get a percentage of what the new owner makes on the sale. Now, under US law, they're not required to give you anything because after the first sale, it becomes theirs. But there are some situations where people might, if they've got a good relationship with the artist, they might give them maybe 15%, but again, they're not required to by law. You could also have a non-destruction clause, which says that, obviously you've put a lot of work into this creative product. You want to make sure no one's going to destroy it. So you can have that in the contract saying that the person isn't allowed to destroy this art. And also, if it's a work of art that might, like a painting or something that over time might need restoring, you can have a restoration clause that says that if the work does need restoring, it can go to the artist first before it goes to anyone else. And then also, if the new owner wants to loan the work to any sort of exhibit that you might not want it to be displayed at, you can have a clause that says the owner gives you notice. Now here we get a little bit of tension between property law and copyright law because the new owner has the title. They got that in the title transfer. They have the title, so it is their property. They can do what they want with it. But if you've retained your copyright, you have the right to display that work publicly. So in that kind of situation, if that does ever arise, you should definitely see an attorney because there's a huge issue between property law and copyright law. So that's the situation where you would definitely need to speak to an attorney to see what can be done. And then there's also going to be, if you work with a gallery, there will be consignment agreements. So what a consignment agreement is it's an agreement with the gallery. The gallery displays your work and your art for the purpose of selling it. And that way you don't have to go out and find a buyer for your art yourself. The gallery has it on display in their walls. A gallery such as this one, and people can come see it, buy it. But usually with a gallery, they're just going to have a form contract. So it'll be a contract where you just write your name in where it says artist and sign at the bottom. And so in these situations, you don't really get a lot of bargaining power. And the reason that galleries do this is it makes business sense for them. They're working with hundreds of artists, and it's not fair to them or to their business if they have to have a separate agreement with this artist over here and an agreement with this artist over here. And for them, it's hard to keep track of what promises they've made to each person. So instead, they just make the same promises to every person, and that helps their business run a little bit more smoothly. But your power comes in the form of, if you don't like a contract, you always have the power to walk away. If you don't like the terms that are on that paper, you can always just walk away.
And you're sort of just getting started out and thinking about what you want to do with your life and what you want to accomplish with art. And I can pretty much guarantee that dealing with taxes and paying taxes is not on that list of things that you're excited about when you graduate. But the reality is that taxes apply to everyone, no matter what line of work you're in. And in fact, they can be especially tricky if you're a professional artist. And by artist, I mean visual arts, performing arts, if you're an author, just any sort of creative endeavor. And one reason for that is that most artists are self-employed. So you don't necessarily have a boss or a company around you that's going to keep track of everything. And it becomes your responsibility to keep your own records, to keep an eye on the business side of things. And also, I think everyone would agree that being an artist isn't really like a typical 9-to-5 job, right? I mean, there's this whole creative side to it. And it can be kind of hard to separate that business professional side of art from the creative personal side of art. But taxes kind of force us to do that. So with that in mind, I guess the first point I want to make is that when you're out there and you're making money from art, and maybe you already are making money from art, all of that income that you make is going to have to be reported to the IRS. And it really doesn't matter how much it is. It doesn't matter if this is something you're doing on the side and you have another job. It doesn't really matter who's paying you. It doesn't matter how informal or formal it is. So, whether it's a direct deposit in your bank account or it's just someone handing you an envelope full of cash, you're going to have to tell the IRS about it at some point. And the way that most of us do that is by filing an income tax return every year. So I guess as students, maybe a lot of you haven't had experience with that yet, and maybe you have. But just sort of in a nutshell, the way an income tax return works is you are telling the IRS about every single dollar that you made the previous year. So from your art, from other jobs, investments, no matter what the source is, this all goes into a box and you tell the IRS, I made this much last year. And based on that number, the IRS is going to tell you, well, you owe this much in taxes. So obviously the way that works is the higher your income is, the more taxes you're going to pay.
Small token of our gratitude